the show, and a pretty damn good day to have him any day because of what he does and what he can help break down for us and the legal stuff in sports, and even today's news with USC and UCLA and the Big Ten and what happens after that. Dan, thanks for your time. There's so much to get to, but your thoughts yourself as a sports guy, just USC and UCLA and the Big Ten, the start of what could be two massive conferences or whatever is next.
Well, what's funny is that I guess we should have predicted this, or at least some form of the Big Ten trying to play catch-up after, obviously, Texas and Oklahoma moved last year. I was kind of maybe there weren't that many, but I was thinking maybe, right, a school like Baylor or a school like Kansas would be pretty attractive to the Big Ten, right? You guys, Baylor had just won the national championship in basketball. Kansas, a blue, but obviously ended up winning the championship this year. But I was pretty, public that I think it's an arms race. So, what happened after that? We had this alliance between the ACC, the Pac-12, and the Big Ten. And, for better or for worse, there was quiet, and as has been well reported, no contract that bound any of these conferences in the alliance. So fast forward, right? Kansas, Baylor, those guys stay put. And what do you know? There was a little bit of a civil war amongst the alliance because two blue bloods, Pac-12 obviously loses USC and UCLA. So maybe you could have predicted it, but how Bob Bowlesby kind of solidified the conference, number one, and then this alliance, number two. Maybe people were thrown off the scent. So Big Ten striking when people maybe least expected it.
Dan, I guess as an attorney, there are lessons you can tell to people. Like, if you get arrested, don't talk until your attorney is there. And two, always have a contract, right? This may be a lesson for that.
Yes, and I think so. I mean, people were making fun of the alliance last year, like, oh, this is just worthy of a handshake. I mean, it's in theory billions of dollars that could be exchanging if you guys violate this so-called unwritten alliance, and that's exactly what we have here. So I've gotten the people in my DMs, hey, is there any legal liability between the Pac-12 and the Big Ten? In theory, there's always something we call tortious interference with the contract. If the Big Ten could be potentially accused of violating Pac-10s or Pac-12 conferences, their television contracts, certainly that's possible. But it happens so often in college football, and we never have anything like that. But if you guys remember back in the Big 12 saga with Bob Bowlesby, he accused ESPN of this tortious interference with the contract, helping schools try to leave the conference. So, yeah, that's certainly on the table, but a much easier way to sue if there had been some type of contract and some type of agreement between the ACC, Pac-12, and Big Ten not to steal each other's schools, but not in writing. So a little bit less likely we're going to have a lawsuit here.
Dan, if you're not one of the two schools being mentioned, and as many have said out there, reported out there already, that the Big Ten might not be done. So let's assume there's a couple more that are in negotiations as well. So if you're one of those schools that's not, you're completely blindsided the same way that TCU and Baylor and the Big 12 schools were. What is your first phone call as far as like legal advice and all that? What is the first thing you think those schools are doing right now?
I think what's probably more interesting is the calls that they're getting, right? They're probably getting calls from the commissioner to check in with them to see if, Kliavkov over in the Pac-12 and maybe, whatever. I think, I don't know. We'll see. Even Greg Sankey, right? Can you imagine the fireworks here? If the Big Ten could pull someone away from the SEC as unlikely as that is. So I think any of the Power 5 schools, they're being very mindful. I'm sure they're scheduling meetings as we speak to check everyone's temperature and to see if maybe, right, there's some type of way they can keep those schools on board. And if there's potentially a school that was complaining about something or complaining about any outstanding issues, now it's time for the commissioners to do their job. They're paid very high salaries to try to protect the assets, to protect the schools within the conference. So, if you are not receiving calls, maybe it's your time to make a call to the commissioner if you need some TLC.
Dan, in this day and age, have you ever seen so much that is testing the legal system as we see now across the board?
Well, it's an interesting era right now. I mean, conference realignment has happened before, nothing new, but the NIL era definitely adds another level of insanity to all this because, what are we seeing? I mean, these are all moves to try to create super conferences to try to attract the best talent in the country. And, short of paying someone a very high number, to the NIL process, which, again, it's kind of a murky waters, what you're allowed to do when you cross the line. We don't know because there hasn't been any type of enforcement from the NCAA or state attorney general. So in the middle of all this, you have the conferences saying, you know what, let's build the superpowers here. So, chasing those big television dollars. I will say the one thing that we should be looking forward to on the scale, and maybe this is part of it, I can't tell you exactly why, but we're going to have a debate at some point in college sports. The more these athletes start to look like professional athletes, the more, right, that some court in our country, and there's certainly courts that are dealing with this issue now, they haven't gone all the way up to the highest courts, but we're going to have this conversation. Are athletes, college athletes, are they employees? And, at our professional level, certainly baseball players, football players, basketball players, they get a piece of the television pie. That's something that's done through collective bargaining. And I don't know, maybe the bigger these television deals get, when you add schools like Texas and Oklahoma and USC and UCLA, the more you're going to have athletes underneath those roofs within those conferences saying, man, I mean, they're making money off of my name, image, and likeness. What happened to name, image, and likeness rights? Maybe I should be getting a piece of it. So, obviously these two conversations are happening hand in hand. So you got to be paying attention to the whole landscape.
Dan, what does collectively bargaining, I mean, not to say it's easier in the professional leagues, but you do have more of a nice round number of union members in that. In college athletics, it's a lot more union members. It's a lot bigger union. So what would that look like, collectively bargaining and becoming a union of college athletes?
I think the part that maybe people underestimate, and I think maybe guys a year ago I was warning you that this could be coming down the pike, and we're getting a little bit closer as we speak. But you don't have to collectively. I mean, you get to pick the group that you want to bargain with, right? For all intents and purposes, it could be right Baylor football. It doesn't have to be all Baylor athletes, because if you're a football player, you're looking around, and Baylor basketball as well. Those are the two revenue-generating sports, football and basketball, largely throughout the country. So, it doesn't have to be as big as encompassing every single sport, because at the end of the day, let's say you want a piece of that football contract. I'm not necessarily sure why, if you're a parent of a Baylor football player, why you'd want someone from the Baylor swimming team, to be involved in that conversation. So, if and when we do get there, which isn't particularly close, I'm just saying it's making its way up. It's going to take a school and some athletes to challenge it. But yeah, you could have definitely lines divided across sports, different unions for different sports. It's a very complicated landscape that, unfortunately, we're not here yet. And hopefully the NIL era shakes itself out a little bit before we get to this employee conversation.
Dan, I wanted to ask you a non-college football question since we have you on. I'm sure, and I saw your Twitter feed, you saw the latest on Freddie Freeman and his former agent, Casey Close, who's now come out with a statement who's saying that Doug Gottlieb's comments about what went down were totally false, and now he's seeking perhaps, pursuing some charges or whatever he's going to do, but threatening to respond. What do you make of the whole situation with Freddie Freeman and now his former agent and Casey Close?
So it's in the developing story by the minute. ESPN has a report. I think Excel Sports Management released a statement. I was curious where Doug Gottlieb got that from. He was the only one reporting it, and I don't, he's not a Jeff Passan or a Buster Olney, someone that's usually tied into baseball in particular. So a report came out maybe about, half an hour, guys, from Excel Sports Management. It seems that Casey Close is accusing Braves management of being the ones that leaked that story to Doug Gottlieb, if you just want to read between the lines. So, now you have a whole other element to this. Obviously there could be potential arbitration in that matter if he wants to file a claim against Casey Close. Freddie Freeman can say, hey, you cost me my legacy in Atlanta. You didn't tell me about this final offer again, assuming, those alleged reports are true from Doug Gottlieb. Then the other part of it, which I'm following, as a little lawyer in me, Doug Gottlieb is being accused of making this thing up. So Casey Close is trying to say Doug Gottlieb made it up. It's inaccurate. And now his new report is almost saying the Braves are mischaracterizing it. So Casey Close seems to, he's almost in damage control mode. So, people can threaten defamation a lot, but to win a defamation case against a public figure like Casey Close, you'll have to show that those entities knew what they were saying is false, but they said it anyway. It's this concept called actual malice, which, I don't know, if Doug Gottlieb was told that by Atlanta, he doesn't know it to be false. He heard it from Atlanta. So Atlanta, right, that seems to be the one now that Casey Close is directing his anger towards, that if they really made this thing up, his reputation has been harmed, right, to some extent. So maybe those are Atlanta, those lawyers over with the Braves are now kind of getting their P's and Q's together.
Dan, Deshaun Watson, NFL, that hearing, the NFL, the reports are, and from reputable people, that they want at least a year What do you think is going to happen here? Is Deshaun Watson's side going to take the NFL to court and look at other previous rulings, or maybe even get into the dirt with them?
It's tough to say, right? I think we should point out for the Deshaun Watson, scenario, it's kind of unprecedented one way or the other. There's never been an athlete in professional sports, let alone football, that has 20 accusers accusing him of something like this. Just the numbers are staggering. So it's tough for either side to say that the judge, if they decide, right, potentially 0 games for Watson or a year suspension. There's also talk of potentially an indefinite suspension, that Watson's going to be out as long as the NFL wants him to be. But in terms of an appeal, taking this to a higher court, right, there's no precedent to look back on. If there's any precedent, maybe it's a little controversial what I'm about to say, but the Robert Kraft scenario from a couple years ago, when he was accused of some type of misconduct at a massage parlor, whatever you want to call it, he didn't receive any type of discipline, as far as I'm aware, from the NFL at all. So if there's any precedent that seems kind of similar, Watson's going to point it out and say, listen, last time this happened, it was with an owner who got 0, and according to the NFL's personal conduct policy, owners are supposed to be held to the same personal conduct issues as players are. Yet he was punished for nothing. So if we're really holding to precedent, here's a scenario where someone was, mixed up in a potential massage scenario. It wasn't anything non-consensual with Kraft, but 0 games were issued. So nothing in the personal conduct policy requires some type of crime, some type of criminal charges, or to be found liable by a civil jury. It's just optics, and certainly the optics are bad either way. Yet no owner has been punished for anything like this.
Dan, do you think that Rusty Hardin still sticks with the illegal argument of it's not technically illegal to ask for a happy ending?
I think he definitely wants those comments back. We have not heard that argument come up since that ill-fated trip to, I think it was Houston Sports Radio. Yeah, the comments that will go down in history. It's not necessarily illegal to get a happy ending. I don't know what possessed Rusty Hardin to make that argument.
To deflect, I don't know. Dan, sportsman, I'm telling you, it is a crazy time. What a great time for you. You've been amazing at Sports Law Lust, by the way, on Twitter. It's a fantastic feed, plus what he does, con detrimental as well. Could you have picked a better time to kind of vault out in front of people the way you did? I don't know exactly when it all started, but in recent years?
I don't think so. I mean, listen, I was in the middle of doing our podcast today, covering the Freddie Freeman stuff, covering baseball arbitration. And in the middle of the podcast, right, this USC UCLA news breaks, obviously some breach of contract issues. And then, the topic that we didn't discuss here, Kevin Durant, formerly of University of Texas, he demands a trade out of Brooklyn. So, when you look closely enough, there is usually a legal story to every sports scenario. There's always going to be lawyers involved in some way, shape, or form. And in our show, Conduct Detrimental, we try to bring out the lighter side and just talk as if we were at a sports bar, but we were talking about the legal concept. So, we have a lot of fun with it, and I take great pride in trying to break these issues down in a digestible way for sports fans. Because at the end of the day, I'm kind of a sports fan first, lawyer second. So it comes with the territory.
Thank you very much, Dan, for your time. Craig, anything else for Dan, Paul? All right, thank you, Dan. Appreciate your time. Dan Lust, sports law attorney. It's a great feed at Sports Law Lust on Twitter, and he has a podcast, and he does an amazing job.
The podcast is Conduct Detrimental. You called it Con Detrimental. That's just the Twitter tag.
And also, one thing, on the chat,